safety, and when we get a quorum, we'll go ahead and go. I'm sorry, I saw my prosecutor over here watching over me. I didn't even know he was in here. Thanks a lot for bringing him. It's very intimidating. But Senator Luetkemeyer, we'll start with your bill, Senate Bill 755, and you can begin when you're ready.
Yes, Mr. Chairman, members of the committee, thank you for the hearing. For the record, Senator Tony Luetkemeyer representing the 34th Senatorial District, presenting today on Senate Bill 755. Currently, under the law, someone who is arrested without a warrant can be held for up to 24 hours. Senate Bill 755 extends that period of detention to 48 hours, but only in cases where the person is arrested for a crime that is involving a dangerous felony or a deadly weapon. Periods of detention without a warrant in excess of 48 hours have been held constitutional by the United States Supreme Court as not violating the Due Process Clause. This bill is narrowly tailored to give law enforcement an additional day to gather evidence to support a warrant for the most dangerous offenders. Giving law enforcement and prosecutors an additional 24 hours to gather critical evidence in these high-risk cases balances the rights of the accused with the need to protect the public. And just anecdotally, we've had cases in Kansas City where an individual who was accused of a crime that would fall within the scope of this bill has been released from prison, and during that intermittent time before they were picked back up after a warrant was issued, they've either harmed victims or in some cases committed homicides. And so this is a very serious issue, and it's to give law enforcement that additional time to secure a warrant. Oftentimes these cases will come about on weekends, oftentimes in the middle of the night. Very difficult to get a judge on the phone and to secure a warrant within the current time frame of the law. And so that's the purpose of the bill. And with that, we'd be happy to answer any questions.
Questions for the sponsor? Seeing none, is anybody here to testify in favor of Senate Bill 755? Mr. Prosecutor, proceed when you're ready. Please also fill out a witness form if you haven't filled one out. There you go. Thank you. Turn your mic on there.
Oh,
Ben.
there we go. Is
Thanks.
that better?
Yep.
Usually it's not volume, it's speed. That's my problem. So ultimately, at the end of the day, we are in support of this bill for many of the reasons that Senator Luetkemeyer talked about in regards for giving law enforcement more times to investigate the case. I will say that Missouri is one of the very few states, in fact, it may be the last state that still has a 24-hour period. The majority of states have gone to at least a 48-hour period for these types of offenses. From the prosecution's perspective, we want to make sure that anybody that we file charges against is, frankly, the right person. And as Senator Luetkemeyer talked about, in situations in which a person was released and committed an additional crime, there are also those that we prosecute where we want to make sure that we have enough evidence that we have the right suspect. Over my career of almost 20 years now, there have been times where the information that I have within 24 hours for making a filing charge is enough for probable cause, which is our basis for making any charging decision. After some more time, though, in speaking with family members and other witnesses, it turns out on some occasions we did not have the right suspect. And so by giving a prosecutor's office and law enforcement 48 hours to investigate what are the most serious crimes that we have in Missouri, it gives us the time to take a very deliberative and information-based approach to making any charging decisions. When you look at the type of offenses that this bill covers, it talks about dangerous felonies and it talks about weapons offenses, and it references the dangerous felony statute. These offenses are murder, rape in the first, forcible rape, forcible sodomy, robbery first. They are the offenses in which is the most serious violation to our members of our community, and oftentimes end up taking the longest amount of time to get to trial, the largest discovery process, and the most intense versions of litigation. If on the front end, law enforcement is given the ability to more thoughtfully take through, and I'm not saying that law enforcement does not do a great job, they do, but take a little bit of extra time within that 48-hour window, possibly talk to more suspects, probably have an opportunity to talk to family members after the trauma of the initial crime has occurred. It is my strong belief that you will have better prosecutions, both in regards to making solid cases against suspects that should have been charged and filtering out suspects that maybe should not have been charged. And so at the end of the day, I know that asking to keep someone in custody for up to a day longer seems like a deprivation of liberty in a manner which would be harmful. I think the balancing test that we take in regards to making sure that we get it right is beneficial, and only at the cost of 24 hours in this particular time period. I can think of a case that I prosecuted years ago in which there was a barn swing. It's one of these situations where it's an old farm complex and they have bales of hay, and kids come and they swing and they jump into the hay. A disgruntled employee burned it down after getting fired. And it was an arson first case. There was death of much livestock and an individual's business. And within the 24 hours, when we first started looking at this, we looked at someone who ultimately wasn't the suspect. And it was just within a couple days we figured out, by looking at phone records, by getting other warrants, by taking the time to do it, within a day or two, we actually did have the correct suspect. And so even in my career, there have been times where that additional day would have been helpful in regards to making sure that we had the correct person charged. So for all the reasons that Senator Luetkemeyer talked about, this is to me, a common sense change to the law that frankly benefits both crime victims and frankly suspects of crime in regards to making sure that law enforcement is doing a thorough investigation before incarcerating anybody on probable cause.
Great. Thank you, Mr. Miller. Any questions for the prosecutor? Seeing none, thank you for your testimony.
Thanks, sir.
We're going to really quick take attendance so we have a quorum. Ben, go ahead and call the roll.
Senators Fitzwater, Brown, Bean, Eigel, Razor, Schroer, Williams.
Quorum being established will be an official committee. Anybody else here to testify in support of Senate Bill 755? Proceed when you're ready, sir.
Yes, my name is Matthew Becker. I'm here with the Franklin County, Missouri prosecuting attorney and also member of the Missouri Association of Prosecuting Attorneys. Just to pick up a little bit on what the last witness had to say, it's not just the right person, it's the right charge. Okay, there are, when police are responding to scenes where people have been shot, exactly what happened and what all witnesses need to be interviewed to get the exact picture of what level of assault we're looking at, whether we're looking at a murder or whether we're looking at a manslaughter. That is stuff that takes an incredible amount of time. Again, Missouri is in a very small minority of states that on serious felonies, dangerous felonies, felonies involving deadly weapons is limited to a 24-hour hold. I've had situations where we've had crime scenes where multiple individuals have been shot, which means multiple ambulances, and in this particular case, multiple different hospitals. And in order for a prosecutor, again, they have probable cause. They know that people have been shot. They know the person who shot, but exactly what happened, exactly the right charge that needs to be issued is something that needs to be given some additional time to get right on the day things happen. And so in this particular situation, it happened at 2 in the morning. We've got 3 victims. There's 2 different hospitals. Those victims aren't at the crime scene anymore. Detectives have to go to these 2 different hospitals in order to interview these people. There's situations where we've got security cameras. And, you know, the cops can be there. They can look at the security camera and they say, hey, can I get a copy of that? And say, you got to get that from the manager. They're not here right now. And so come back tomorrow. Well, in a 24-hour hold, that's a situation where the prosecutor's going to have to make this decision on who to charge and what specific charges to file without the benefit of having a copy of that video. There are some things that already are in the statute that I think we need to pay attention to here. Somebody who's held for presently under 24 hours, and if this bill is passed for 48 hours on dangerous felonies and felonies involving deadly weapons, they still have the same rights as they would under the present bill, and that includes the right to speak with an attorney. And within this bill, it does make clear, rather the present statute, someone who violates this, somebody who without good cause holds somebody, is in fact guilty of a Class A misdemeanor. Just kind of to wrap these things up here, in conjunction with the new bond rules, there are decisions, weighty decisions that happen early and in a timely fashion, and allowing this additional amount of time to make sure that we've got the right charges correctly filed, because we really don't want to be in a situation where charges are filed on bare probable cause. You really want to give law enforcement, prosecutors, the judges who are receiving these charges, who are setting bonds, you want to give time for a thorough investigation to have been completed before decisions like that are made at the very early stages of a criminal prosecution. One final point. These time frames are not exclusive of weekends and holidays. 24 hours is 24 hours, whether that's under the present rule, whether that's a regular Tuesday afternoon or whether it's Christmas. And this 48 hours would be the same thing. It doesn't matter if it's a weekend holiday. Every single minute counts the same. If we're going to issue a charge on Thanksgiving weekend, we got to issue it on Thanksgiving weekend. We don't get to wait till Monday if that's outside of the 48 hours.
Any questions for this witness? Seeing none, thank you for your testimony. Anybody else here to testify in favor of Senate Bill 755? Thank you, sir.
Mr. Chairman, members of the committee, Andy Arnold here today in support of Senate Bill 755 for the Kansas City Board of Police Commissioners and the Kansas City Police Department. Everything's pretty much been said. The senator's right. There's been cases where somebody's been let go after 24 hours, and they've gone out and intimidated witnesses and committed additional crimes. So this is something that we would like to add.
Questions for this witness? Seeing none, thank you for your testimony. Anybody else here to testify in favor of Senate Bill 755? Anybody here in opposition to Senate Bill 755? Let's proceed when you're ready.
Thank you, and I will fill out a form before I leave, I promise. Sharon Galway-Jones here today on behalf of Dream.org. We are a criminal justice reform organization. We are opposed to the bill in its current form, and honestly, on principle, think that 24 hours should be enough, especially if it's post-arrest, because you can do a lot of the investigation before you get to the arrest warrant point. However, given the recent changes that we have made to the definition of dangerous felony, we are focusing kind of on where that is at. We included armed criminal action in the definition of dangerous felony, I think 2 years ago, maybe, something like that. Armed criminal action includes anything that is done while wielding a dangerous instrument. And the real problem here is definition of dangerous instrument. A dangerous instrument can be a heavy phone case. It can be a beer bottle. It can be anything. It doesn't have to be, in fact, it doesn't include knives. Knives are included in deadly weapons. So the fact that we have increased what we would think of as a dangerous felony, first degree assault, that sort of thing, to anything that could be included in armed criminal action has greatly expanded that definition and therefore expanded the number of people that could be held for 48 hours. And while I do know that the law says 24 hours is 24 hours, 48 hours is 48 hours, we do know districts that play with that number. And we have folks who end up never getting charged, but have not been 2 days, no call, no show, have lost their job for that reason, find themselves suddenly without a home, find themselves with their car repossessed, things like that. So I think there are some things we can do around this where we can find some middle ground, but definitely the fact that we've got a very expanded definition of dangerous felony and the fact that we've got no consequences if that person is never charged but has experienced significant financial setbacks because of the hold are things that we need to kind of talk about as part of this discussion. With that, I'm happy to take any questions.
Questions for this witness? Seeing none, thank you for your testimony. Anybody else here opposed to Senate Bill 755?
Mr. Chairman, members of the committee, Brian Bernsker here on behalf of the Missouri Association of Criminal Defense Lawyers want to go on record in opposition to the bill. This has been a concept that's been around for quite a long while. Former Senator Claire McCaskill was one of the first people to bring up the option of increasing from 24 to 48 hours. The prosecutors and the police have done a good job just detailing how difficult their job is. And their job is supposed to be difficult, but what they're doing is taking away your liberty. And I know that you all regard liberty as very precious. And I think we can actually stand proud of the fact that we are one of the few states that doesn't regard this as an opportunity to take away your liberty unnecessarily. I couldn't get one of our lawyers here, but they can talk to you about the absolute horror stories of their clients spending time in jail when they have not been accused of a crime. And as far as they can tell, they haven't done anything wrong. I know the prosecutor said only 24 more hours, but imagine one of your loved ones stuck into jail for an additional 24 hours when they haven't done anything wrong and they haven't been charged with a crime. We think 24 hours is enough time given the circumstances, and we'd certainly appreciate you all continuing that policy. Happy to answer any questions.
Questions for this witness? Seeing none, thank you for testimony. Anybody else here to testify in opposition? Anybody for informational purposes only? Seeing none, that'll conclude the hearing. Thank you, Senator. Any closing remarks, or are you good?
I'm good. Thank you for the time.
Thanks, Senator. I now move that we move into executive session. Second, we have a second. All those in favor say aye. Opposed, no. The ayes have it. We're in executive session. I move that Senate Bill 808 be brought before the committee. Do I have a second? Have a second. All those in favor say aye. Those opposed, no. The ayes have it. The bill is before the committee. This bill was presented 2 weeks ago, puts control of the St. Louis City Police Department under the control of the state of Missouri. Senator Schroer does have a committee substitute ending in .02C that I believe has been distributed. And Senator, if you want to offer that substitute and explain it, you can go ahead and do that.
Yes, I believe this was dated January 16th, substitute, which gets us back to the version.
Senator, if you can use the mic too, because I think it's streaming. Gonna have that.
Yeah, so this was distributed, I think, back on January 16th. And this is essentially the version that, instead of what was filed out of the Senate last year, this is what actually came into the Senate's possession last year. So this puts us back in the same exact position after the House sent this over to us last year on, I believe, let me see, House Bill 702, I believe. But yeah, this just gets us back in line with where we started off last year.
All right, I move that we adopt the sub ending in .02C, having a second. Is there any discussion on the substitute? Seeing none. All those in favor say aye. Aye. All those opposed, no. The ayes have it. You've adopted the substitute. We'll now go into executive set, or we'll vote on the committee Senate committee substitute for Senate Bill 808. Any discussion on that? Seeing none, Ben, call the roll.
Senators Fitzwater, Brown, Bean, Eigel, Razor, Schroer, Williams.
I'm going to vote no, but I'm going to be working with the bill sponsor because I have some serious reservations about what's happening in St. Louis when it comes to public safety. And I'm in the conversation now with local folks to get a better understanding on what they're going to do to deal with this. And once that's clear, that'll place a more clear stance on where I go moving forward. So I'm voting no, but we'll be having serious discussions with folks in St. Louis, and that'll play a role in how I move forward in the future. Thank you.
By your vote of 5-1, the motion carries. So moving on to Senate Bill 799, I ask that be brought before the committee. Do I have a second? I have a second. All those in favor say aye. Those opposed, no. The ayes have it. The bill is before the committee. I now move that Senate Bill 799 be voted out of committee. Do pass. I have a second. This is my bill on property tax on a depreciating schedule. I do have a substitute that we just got. We just got a substitute this morning that would take it from 15 years to 12 years. We want to have, in the event that we ever get this to the floor, have a fiscal note that is accurate. So we have the opportunity to have a good discussion on that if we ever get to it. So I have that substitute. I'm going to offer that substitute. I make a motion to that substitute. Do I need a second for that? So I move for its adoption. Any discussion on the substitute? The only change is from 15 years to 12-year depreciation schedule. Seeing none, all those in favor of the substitute, say aye. Aye. All those opposed, no. The ayes have it. We've adopted the substitute. Any discussion on the underlying substitute and bill? I now move that we do pass Senate Committee substitute for Senate Bill 799. Having a second, all those in favor say aye. Aye. All those opposed, no. The ayes have it. You've passed. I'm sorry, we have to do a roll call vote. Apologize. Ben, call the roll.
Senators Fitzwater.
Aye.
Brown. Bean. Eigel. Razor. Schroer. Williams.
By your vote of 6-0, you have voted do pass Senate Committee substitute for Senate Bill 799. That is all we have for today. Thank you all for showing up for the hearing, and that'll conclude the hearing on transportation infrastructure. What's that? No, only one. Yeah, we had a late cancellation.